Well, good morning, everyone. It's a real pleasure to be here and to see so many of you here. I actually met several people this morning and had the pleasure of shaking hands with people, so it's wonderful to be back at a live event. As Ariel mentioned in his opening statement, mentioning so many cases, it's a very exciting time to be involved in collective actions. We're involved in several matters at the moment and are really interested to see how these things develop going through the legal process. Now, before I go on, I'd like to introduce you to my illustrious panel. I have on my right Christian Schmidt, who is a disputes partner in the Pinsent Masons Munich office. He has more than 10 years' experience in the field of large-scale mass actions in Germany, both in financial services and the automotive sectors. Next to his work on collective redress projects, Christian is particularly focused on complex technical and financial disputes and the integration of legal tech in the field of dispute resolution. I have also Lochy Macpherson, also on my right. He is a legal technologist specializing in group claims. He is also commercial director at FinLegal, and they are a legal technology company which operates the world's first cradle-to-grave technology solution for claimant management, with the goal of using automation and self-serve mobile-first technology to bring down the barriers and costs associated with pursuing group claims. Also online, I have Chris Warren-Smith. There he is. It's good to see you, Chris. He's joining us virtually. He's a partner in the Morgan Lewis litigation team in London. His experience in class and collective actions in the UK, US, and elsewhere covers several decades. Chris will, in particular, be discussing the development in the UK market in the light of developments in the US and elsewhere in the world. And I'm Pinar Bagci. I'm an economist with the Brattle Group. I've been working on regulation, competition, litigation, damages for nearly 25 years now. I'm currently retained as expert in several collective proceedings before the UK Competition Appeals Tribunal and the UK High Court. Now, our role this morning is one of scene setting. We are going to actually provide an overview of many of the topics that other panels will go into in a great deal of depth. So what we thought that would be helpful for everyone is if we go through each process of a collective proceeding to discuss the legal, economic, and practical issues that arise. And we will also be comparing our experience of working in different jurisdictions. Now, I want to start off with key themes and pre-certification issues, and I'm going to ask each of the panel to give me a couple of minutes on what they consider to be the main issues. Chris, I'm going to start with you first. Chris, on the screen.
Thank you, Pinar, and hello, everyone. It's good to be with you. Pinar, am I coming through clearly enough?
Absolutely, loud and clear.
Excellent. Great. Well, I mean, if we think about key themes, if we look back over recent years, decades of these sort of events and looking at law reform around the world, how countries try to have fair, collective and class action regimes with proper access to justice. The themes that come up time and time again are firstly, funding. How should these actions be allowed to be funded? Secondly, what is the regime? And in particular, the difference between opt-out and opt-in and which is more effective for particular countries and regimes. And the third is very much, what is the disincentive? How do we disincentivize poor claimants, whether it's by having a loser pays system or otherwise? And we'll probably talk more, I think, over the next session, in this session about the first two issues. But in terms of trying to just give some opening comments from my perspective, I think the first is where we're seeing probably the most traction, and that is through third-party financing, third-party funding, call it what you like. And certainly in the UK, that is happening, yes, in connection with the more formal processes, such as a group litigation order, representative action. We've already had the Supreme Court decision mentioned, follow-on certified cases. But what we don't see as much of, but is really a groundswell, is other types of collective actions, where effectively they're judge-managed, there'll be multiple actions pursued at the same time, managed by the court. And so there's a lot more, I think, underneath the surface than people see. And just to give a bit more context, perhaps, my practice, like other colleagues in the London office, we act on the defendant side, but also on the claimant side. So we see these things from both perspectives. And the types of actions we're seeing third-party funded are multiplying. Securities action is now becoming increasingly common. Environmental, tax and investment cases, clearly competition. So we're starting to see a lot more types of actions funded. And another dynamic is that I think some people thought a number of years ago these funders were going away. Well, they're not. And also we're starting to see far greater expertise within the funders themselves, also the law firms they work with on the plaintiff and claimant side, and also organisations such as Lochy, which start to bring, if you like, management techniques into the mix. And this is a, generally speaking, very intelligent deployment of capital. So these funders are also starting to break new grounds. They'll test procedures, they'll test cases in a way that a business or a private individual won't necessarily do. And again, to the theme of this panel, we'll see them more and more test cross-border opportunities. How can we pursue some cases in one jurisdiction, possibly settle in another? So I think one of the things, this obviously this will be talked about a lot more later, but from my perspective in the UK and elsewhere, we're really seeing funding as a dynamic that's changing the market significantly.
Well, thank you, Chris. Christian, do you have anything to add to that from a German perspective?
Yeah, absolutely, Pinar. Thank you. And as Chris mentioned, I think the funding is indeed one of the big topics where we are seeing a lot of changes over the last years. Talking about the German market, I would say funding did not really exist that much in Germany until maybe 20 years ago. It was different in other markets, but in Germany it is a pretty recent development. And it started usually with the big one-off cases between the big corporates. But now we are seeing that getting a lot more traction also in consumer-related disputes, in mass actions, class actions. And this is really a new development we see in the market, although still the major funders are sometimes a bit hesitant, cautious, because maybe they don't know the market so well, they don't know really how the procedural mechanisms work. But we see a lot more of that coming down the line, and I think we will see a lot more coming also in the years coming forward. So this is for sure a hot topic to discuss. That's the first one. Second one, clearly you have all heard about it. The European Union has issued the Representative Actions Directive, which will be transposed into national law by the end of 2022. So we will see big developments in that field. Depends on the jurisdiction, of course. I mean, I've just talked to a colleague from the Netherlands who said, well, we have that all in place already, more or less. But in Germany, this is not the case. So in Germany, we have the Declaratory Model Action and the Capital Markets Model Case Act, which never really got traction so much in the market. But the RAD, this directive, will bring big changes to the German market. So for those of you who haven't heard about what that is, basically it is a mechanism that is supposed to bring some kind of harmonization across the European Union. And a qualified entity is supposed to bring the action on behalf of the affected consumers. And it is about violations of European consumer law. So it can be every kind of consumer law topic. It can be competition law, potentially. It can be data protection. It can be environmental. It can be travel. It can be all these kinds of topics. So that's going to be a big development we see in the market. And the third, very important thing for the defense side, basically for the big companies affected by this, is strategy. So you need to really look at your strategy. You need to put mechanisms in place to detect those waves of claims coming at you before they hit. And I think this is something that we are constantly telling the clients. Horizon scanning is really one of the very big topics these days.
Okay, so we've touched on some legal issues, some funding issues, some complexity issues. Now, there are lots of practical issues to consider as well, as you're all aware, in bringing these very complex mass collective actions through the legal process. Now, Lochy, you're really on the practical side of things and the logistic side of things. Could you tell us what you think the main issues are?
I like to think so. I suppose the first issue that I would bring up is you're going to have to find your claimant group. And it doesn't matter if it's an opt-in, if it's an opt-out, any other variation on themes. It will change when those actions have to take place, but you're going to have to go and find that claimant group. They may not be as engaged as an ordinary client. They may drop in and out of engagement during the process. They may even be distrustful of the process as a whole. So that's going to be a theme, having to go out and find these people in practical terms. You're then going to have to put them through a number of processes. And that's a key issue, how process-driven this is going to be. Because although a lot of these processes are simple, and you could easily do them for a single client here or there, you're going to have to duplicate this across a huge number of claimants. And you simply won't have the time to engage with each one of them individually. But if you don't, what you're going to find is that you'll lose engagement over time. So you'll have that balance to strike between the quality of engagement on an individual basis and the cost implications of engaging there. You're going to have to find that balance, and you will inevitably find that there is no such thing as a standard customer. So no one's going to fit into an easy path. People are going to fall out of the process. People are going to need to be dealt with individually, need to be dealt with personally, to keep them involved in the process. The second sort of practical element that I would bring up is that you're going to have to gather and interpret evidence on a huge scale, which is, of course, where your work comes in. Now, again, this is the sort of thing that could be done individually, but you're going to want to bring in elements of self-service, elements of automation to drive this along, because dealing with data at this scale brings all sorts of problems along with it that are going to be very difficult to work with. So my second theme would be the scale of data and the difficulties around interpreting it, which wraps up quite neatly into my final theme, which is around management of cost. Margins can be thin on many of these claims. You want to keep things moving. You want to keep things practical. There may be cash flow issues where funding is obviously one option. But you're going to want to keep costs down throughout. And the key driver there is going to be the time that you spend per client. And from a technology basis, that's where we would seek to help.
Well, now that you've made it sound so easy, we thought that we would start with talking about certification and what's required to get a claim, a collective claim, to the certification process, touching on the legal, sort of practical, and other considerations. So I wonder if, again, I can turn to you, Chris, just to sort of ask a bit of a cheeky question. Where would you ideally like to bring a claim?
Well, for me, the answer to that is the same as most commercial disputes, which is if I'm a plaintiff or a claimant, I want to be in the US first and foremost. If I'm a defendant, I want to be outside the US. And so, if you look at the US class action system, it's opt-out, it's no loser pay, it's well-defined, you know the rules and procedures at state and federal level. So broadly speaking, that's where people will try to go. But let's assume that's not available because there's no nexus. Then you're looking at other established jurisdictions, and some less so. And if you look at the UK, for example, certification is part of the picture, but only part. There's really only two ways of having an opt-out class certified. One is, since 2015, we've had the Competition Act, the competition claims, and we now know there are two of those, which are being discussed subsequently, and the other is representative action. And of course, we have a Supreme Court decision last week saying, well, yes, it's appropriate for this type of case, but not for this particular case because it won't deal with damages. The rest of them are either opt-in or case managed. And so there's actually a lot of flexibility, if you like, in how you create a claimant group, pursue claims, and put pressure on a defendant. And it's helped, if you like, from the defendant's side, because it is an opt-in system. And there's claimant apathy, there's cost, there's all sorts of factors like that. There is a downside, though, and I always tell the story. I had a case in 2004. We had three group litigation order applications in front of us, and the chief exec of my client defendant said, I'd really quite like to settle this case, Chris. And I said, well, yeah, but these actions comprise 9% of the potential claimant population. So there we had a willing client who really did want to try to resolve these things, but we couldn't get any type of finality. So you're forced with fighting the application and winning or losing, which is much what happens in the States and also other parts of the world. And you look at group litigation orders were introduced nearly 20 years ago now, and over 20 years ago, and there's still only 100 and something, and the number hasn't really increased much over the past few years. So in a funny way, the certification process isn't working. It's not working, but it's not driving how these things are being delivered. So again, and it's the theme that we're talking generalities here, but the theme is that there's flexibility, and particularly, Christian mentioned the EU changes. They're very important, and so I think we're going to see a lot more flexibility within and around the UK system, and also European system that we've seen in the past. And we've already seen, settlements of class action where you'll have US-driven class action, a component settlement in the Netherlands, for example. And we're going to see more of that, I believe.
So I abruptly cut you off, Chris. I'm just wondering, do you want to make a final comment before I pass on to Christian?
No, I don't think so, Pinar. I think really I was just making the point that I think there's going to be opportunity for arbitrage and all sorts of flexible solutions as regimes develop. So I think that I've said enough on that.
So Christian, you heard a little bit about the UK and the US processes. I mean, how do you feel about both bringing and defending claims in Germany and other European jurisdictions?
Yeah, I think picking up on Chris's comment earlier, I think it's really the question of where would you like to sue if you are a claimant, and why would you like to be sued if you're the defendant? So maybe if I was a claimant and I could choose the forum, I would also go for the US. But for the defendants, maybe Germany was quite a comfortable jurisdiction so far. And again, the European Representative Actions Directive comes in here that might bring some change into that field. But so far in Germany, as I mentioned earlier, we had those mechanisms already, but they didn't get a lot of traction so far. And also the declaratory model action was only brought into the market in 2018. So there was also not a lot of time to test it. So far what happens in mass actions cases in Germany is that you will see thousands and thousands of individual claims brought to the court, sometimes with truckloads of files before we had the electronic filing. And then those go on for years and years, keep the courts busy, overwhelming the courts. And those were opening up the field for a very different defense strategy, obviously, right? So if you were the defendant, you could robustly defend against every single litigation. You could identify those that would become more dangerous, where you get negative indications, settle those quietly, silently with an NDA, and then proceed with those where you had a favorable fact pattern, get those to the Court of Appeals, get the positive indications, and then maybe ultimately proceed to the Federal Court of Justice. So this strategy might have to change coming forward with the Representative Actions Directive, because this RID will implement some kind of mass action system where you will face one representative action and you have to get that right. So the strategy might change. That is a big difference. We have also seen, next to these individual claims, we have seen attempts at bundling of claims. This is an interesting model as well. So you set up an SPV, some kind of company, and the claimants assign their claims to that SPV. We have seen that also in competition cases. Many of you have maybe read about it. But there is a lot of challenges to this model. There is potential for conflict of interest. There is a potential violation of the German Legal Services Act. And the courts have so far issued quite different decisions and opinions as to whether that is viable or not. So as a claimant and as a funder, you might not want to risk or place your bet on that. And we have to see how that proceeds going forward.
Okay, and I understand the RAD doesn't apply to competition claims, is that right?
Indeed, so the RAD itself doesn't apply to competition claims, but it is on the member states to decide how they want to implement it. So once they implement it and they put a new mass action system into practice, they are free to extend the scope also to competition claims, but that will be on the individual member states.
And do you think that the RAD is going to actually improve the efficiency of the process, bring more light to the process? How do you see it? Yeah, so it's a bit of reading tea leaves so far, because we haven't seen the precise drafts for the legal bills that will put that into place. I have heard, and I've discussed it with many practitioners, I've heard all kinds of comments ranging from, well, that's not going to be so much change. We have similar things in place in Europe. It's not going to change a lot.
There's other people who say this will be a radical change to the system. We will see big actions funded by international third-party funders with really powerful claimant firms behind it that have not yet been active in the claimant space because they didn't see the business case behind it. So my personal opinion is, combined also with legal tech, like Lochy has just explained, the RAD can bring a really big change to the system. And I think everybody needs to prepare for it and look out for the draft bills.
So Lochy, imagine that you have several large claims in multiple jurisdictions. Can you tell us how you would go about trying to reduce the costs, improve the efficiency of those claims?
Yeah, so I'd come back to my sort of key theme, and you'll hear me hammering this over and over again, but it's the core issue is going to be the time that you're spending per claimant. You're going to have to bring that down, and there are various ways through which you can do that, but the core, but repeatability is going to be key to it. You need to have a process-driven system where things are repeatable, where people can go through the system and self-serve. Mobile first is really useful in that regard. People are so used nowadays to tapping into their mobile, a few clicks here and there, and they can sign up to anything. You can get on a flight, you can buy tickets. It's no different when it comes to mass actions, group claims, anything like that. It's what people expect. They actually prefer it often. In terms of the sorts of proceedability questions and things that you'll put through to them, in terms of evidence gathering, I think we'll talk later on OCR as a particular theme. There are lots of these automated techniques that will help you to bring down cost and move you to a situation where you're managing by exception. You don't want to be diving into every individual claimant. Most people, 80%, will proceed through and self-serve, deal with themselves, and get through the process. You only need to pick out the individuals who are causing complexity and make sure that you bring them back in and get them back on the process. So repeatability is the core here, and time per client is going to be the metric that you'll be aiming for to keep costs down.
So I guess it's going to be rather challenging to do that if you have a very diverse set of claimants, like in some of the collective proceedings that are going through at the moment. I can imagine maybe for 2/3 of the claimants your model would work, but then there are quite a few exceptions. So it's interesting if you compare something like the Merrick's claim with 46 million consumers to something like the FX claim, where the number of claimants is sort of more in the tens of thousands. So one, you have a lot of similarity. Another one, you've got a lot of heterogeneity. So how would you approach those two different types of claims?
So there's always going to be nuance to individual claimant groups. And the other nuance here is, of course, that those claimant groups may slightly move over time as claimants drop in and out with engagement, as you find out new information about them that brings them into new groups. So these groups are fluid. There is always going to be a degree to which you can standardize and a degree to which you can't. And the key is finding the elements that are repeatable and rolling them out across the group, and then accepting where you're going to either need to learn on the job or have a person, and you're going to have to choose the skill of that person, and of course the cost associated with them is going to pick up the differences, the nuances.
Okay, so far we've we've got the funding, we've got the class, we've got the sort of the go-ahead from a legal and economic perspective. We're at the certification process, and this is my favourite part actually, is the discovery and evidence, the early part of it. Christian, I'm going to ask you just to start us off by talking about what sort of information and evidence is required and how that might change throughout different jurisdictions.
Yeah, absolutely, Pinar. I think this is a topic that is very different depending on the jurisdiction you're in, and this is also one of the cross-border challenges that we see, which is why we have also seen that many claimants are actually shying away from filing cross-border suits because of just the unfamiliarity with the system in another country. And talking about Germany again, and also the Representative Actions Directive, as many of you maybe know, in Germany you don't have, for example, this kind of discovery regime that you see in many other jurisdictions, right? So In Germany, as a claimant, the general rule is, as in many other jurisdictions as well, you have to prove your claim. But you don't have access to discovery. There's a very limited scope only for that. So especially in big mass actions cases, mass harm cases, you might have quite some trouble finding the evidence and the information that you need to bring your claim. And so far, claimants are often trying to rely also on criminal proceedings. They do inspections of files, Freedom of Information Act requests to authorities, just to try to gather information that is necessary to bring their claim. And here again, the Representative Actions Directive comes in, because in its recitals already it recognizes this asymmetry between the claimant, the affected consumer, and the big corporate on the other side of the table. And it tries to somehow balance that by introducing some kind of discovery scheme into the Representative Actions Directive. Still, that is mentioned in Article 18, but we don't know how far this will go in the implementation, because it's up to the member states to decide, and also the RAD is not touching basically the member states in basically implementing their procedural regime. So it will not interfere with that, but there is the requirement of having some kind of discovery proceeding, and that will for sure also bring some change to the German system, where you have not seen that so far. And this might make it easier for claimants to file cross-border proceedings. Maybe one more comment as to the experts, because that is also your topic, Pinar. Maybe also as a difference to other systems in Germany, we don't have party-appointed experts in the litigation proceedings as such. So we have, as a party, you can of course bring your own expert, you can file expert reports, but those will just count as submission of facts. So the court will, if that is necessary to decide the case, will have to appoint court-appointed expert. And that expert will then issue an expert opinion, will be heard in court, but we don't have this system of party-appointed experts.
Well, it's interesting because, as many of you are familiar, in the competition claims, we currently have the certification process in which expert reports are filed, but the experts aren't really cross-examined. And even though, strictly speaking, there is no sort of detailed merits assessment at the certification stage, it's inevitable that there is some merits assessment. So the question at the moment, in my mind, from an expert perspective, is, are we going to go through the whole thing twice in terms of presenting expert evidence and having an assessment of it? And what is the function of the certification process as a gatekeeping role? Given the low threshold we have, so-called Canadian standard for competition claims, is it really going to be that all claims just pretty much go through? And if gatekeepers do not sometimes refuse claims, then what's the role of gatekeeping? So Chris, I was going to ask you to comment on your experience of evidence and discovery in the certification process in particular.
Yeah, I think the thing I would say that the general trend about disclosure discovery, again, as Christian explained, there's a difference between the civil and common law regimes, but certainly in our common law regime, it's a lot more difficult. And of course, what we're seeing now is by the time we have the collective litigation, there may well have been prosecutors in the UK and other jurisdictions sharing information, regulatory interventions, public inquiries, media scrutiny. So we've worked with the communications strategists and the regulators and prosecutors sharing information across border under memorandum of understanding. So all of a sudden, something that used to be quite straightforward is really quite difficult. And so what we're finding as a general rule is that the profession and practitioners have to find ways of disclosing information with confidentiality constraints and being quite flexible in how we make sure that proper disclosure is made whilst protecting parties' interests. So I'd say, as a general comment on disclosure, it's just becoming more difficult. But and I think that the onus is on us in the profession to try to find ways around that. I think and your comments, Pinar, I certainly couldn't add to from a competition perspective. I think what we're seeing as a trend somewhat in the High Court is that sometimes because of claimant apathy, sometimes because of difficult subject matter, increasingly we're needing to find ways of having an expert, used in the wider sense, get evidence before a court. And that expert may be talking about how a market works. And so we can have very arid debates about whether that's factual evidence or expert evidence, but we're starting to see a need, particularly where we have significant claimant groups, so both claimant and defendant, to produce expert reports that are quasi-factual. And it's a question in each case and on each application whether judges will permit that. But in general, where it seems sensible and proportionate and meets the needs of justice, they will. So I think that's the other trend we're starting to see, the use of expert and quasi-expert reports to cover deficiencies in the facts that we can present to the court.
And so, Lochy, I mean, I know that this is sort of more of a substantive issue than a sort of a practical issue. But how do you work with different jurisdictions and the different evidence requirements or the fact requirements in each jurisdiction?
I suppose to take it back a step further is how we deal with gathering evidence from those individual claimants en masse. And something to pull out here is that, as a rule of thumb, you should not be asking people for evidence where you can avoid it. There are plenty of lookups available, there are databases available, you can go and find this information, you can pull it back. And the push should be to present information about claimants to claimants and simply ask them to confirm it. You're going to get a much higher engagement level doing that than you are asking them to drag through old invoices, go and find things. And there are lots of toys available to get that information to you. So it might be that you go down the SAR route, you're requesting lots and lots of information, but what comes back can be messy, difficult to work through. Depending on the claim at hand, you might have a more workable defendant who's happy to agree with you how information is going to be released, in what format. The more standardized you can get that information to arrive with you, the more you can start to build automations and things into that. If you do have to gather evidence manually, again, you can reach out to people, they can self-serve, they can drop things in, but OCR is a growing solution here. It's constantly improving. It's not perfect. I'm sure there are people in this room who've had issues with OCR solutions previously, but certainly it's a great way to scale. And if I take an example of a follow-on claim in Europe, antitrust claim, gathering invoices from 10,000 different claimants over a 15-year period, this is far too much data for an individual, even experts, to be able to deal with. There are solutions available that will allow you to reach out to those claimants, to scan historical invoices, to find gaps in those invoices, automatically reach out to the claimants to say, you're missing November 2019, what's going on here, can we have it back? As they build that up, the system will be able to recognize that, but also extract information from it and start building that into a playable format. So it will start being able to apply simple business rules, logic rules, to calculate quantum off the back of that. All of that can be automated. That's not a manual process that needs to be done by an individual, and it's not really clear how an individual could deal with that scale of data, especially at that stage in the process. The only other point that I would throw in terms of managing data as part of discovery is workflow management. If you have multiple parties working on the same data set, especially if it's large, you don't want to be extracting that data set, sending it onto one system, extracting it onto another system. Every time you do that, you're going to add complexity, you're going to add cost, there are reconciliations that need to be done. That's all going to have time implications. Workflow management, or managing a workflow properly, means that you can have multiple parties engage on a single data set. They can add their part, they can push it on, pull it back as required, and you can step things through a process. There's no reason why those dealing with evidence in a law firm are going to have to extract it and send it over to economic experts to deal with on a completely separate system. You can manage that through the process and push your evidence.
Okay, well, going from the practical issues, I'd like to get back to some substantive issues. We're running late. So if I could just ask you all to comment on some strategic issues. In fact, Chris, I'll go to you first. If we assume that we've actually got to the process where we've had a successful claim, we pretty much know what the disbursements might be and so on, and then maybe we're even thinking of settlement. What sort of strategic advice would you give to your client, either on the claimant or the defence side?
Yeah, and it's particularly often challenging on the defence side, again, where for some of the reasons we talked about earlier, it's become more challenging. So presumably you sat down at the start and identified all of the relevant stakeholders, so prosecutors, regulators, business partners, members of the board, business units, insurers, employees, etc. So you've done all that at the outset, you've worked through and continued to evaluate all of these, and then you come to look at a settlement. And of course, any settlement, the one thing we all want is total peace on the defence side. Now, how possible that is will depend upon a lot of the other factors. So, for example, not uncommonly, you'll have a criminal prosecution of an individual which outlasts your settlement. So you need to think of the ramifications of that upon your potential settlement. You may, again, and this is particularly prevalent in the opt-in system in the UK, you may be facing other potential claims on the same subject matter. Very often you'll see claims pursued and others have watching briefs while protecting their positions on limitation. Now, you might have read about some of those things in the papers, you may have had some inquiries, you may even have received letters from some of the law firms representing those other groups of claimants, but very often you'll have those issues as well. And so what is very difficult and challenging at times is that there will be no right answer, and you can be forced to settle a particular action knowing that there are others in the wings. And this is where, again, I think the theme from this panel has been, as the regimes increase into Europe and elsewhere, there may be more opportunities to find ways of getting total peace earlier, differently or better. But no, strategically, it is a matter of identifying early, managing and addressing all of those things, and then being very real about them and understanding the risks when you do begin to enter into specific settlements.
So, Christian, after that, so imagine, for example, we heard in the news yesterday that Visa and Sainsbury's have settled on their interchange fee matter, but there are a number of other claims in the process. If you were sort of involved in that process, hypothetically, I don't know if you are, but what sort of advice would you give to either the claimant or the defence side if you're watching it?
Yeah, absolutely. I mean, I think, Pinar, it all comes down basically also to what Chris has mentioned before. I mean, it really depends on the different stakeholders in question. I mean, looking at those kinds of big claims that we have seen in Germany, for example, you always also were facing the risk that you had those, for example, a declaratory model action with hundreds of thousands of claimants registered, and then you have next to it individual cases also running. Then you have to look at the time limitation, When does the limitation defense kick in? Have you seen all the claims that can be filed already in court? Can you make an assessment of how much it is? Or would you encourage other people to file their claim, if that's still possible, by making a favorable settlement for the claimants? And in the end, it's like Chris said, there's no right answer. It all depends really on the individual circumstances of the case. It depends on the strategy that you have. And also it's an incentive that you have to give to the claimants, right? So, and at the same time, if you have a collective action scheme, the court might also have a say in it, right? So the court might have to decide on whether that settlement is fair, whether it accepts it. And then in Germany, for example, with the existing system, claimants can opt out of the settlement. So even if the court approves, if the claimants don't see that this is a fair compensation, they might opt out of it, and then you pay a large amount to some, and then the others opt out, and they put pressure on you even more. So I think it all comes back to the initial remarks I had about strategy. It's really about the strategy early on. Consider what's at stake, what's the incentives for the different parties, and what's your ultimate strategy to get rid of the claim as early and maybe cheaply as possible if on the defense side, right?
Yes, well, listening to my panelists, it seems to me that the collective actions process is a bit like conducting an orchestra, where you have so many groups to manage and to oversee, and each come in at different times, and that somebody has to have this overseeing role to make sure that everything works in harmony. I think given all our interruptions, we're a bit late, but I'd like to open up for questions that you may have, and any questions online.
We have one question from one of our virtual delegates, Martin Eimer. He said, on the cost management of mass actions, isn't this a very delicate balance to strike, given that early court action driving things forward at less or reducing cost often cannot be based on a comprehensive facts basis, given that facts tend to come to light over the years only, for example, following criminal investigations? We see very different strategies applied by claimant firms, bringing actions early, trying to win the market, while others advise claimants to remain patient.
Would you like to have a go, Christian, at answering that?
Yeah, happy to answer that, Pinar. Having acted both on defendant and claimant side, it is actually a very delicate balance to strike, I have to say. So you have to keep in mind that once you file a claim, there is only so much you can bring to the table after you have filed it. So depending on how fast the court progresses with your claim, it might be that after half a year in Germany, in the German market, after half a year you're already dismissed with your claim, and then you're at appeal stage. But at appeal stage, technically it's not possible to bring new facts anymore. And then you might eventually lose just because you were too early in the game. And then on the other hand, if you wait for too long, people go with another action because they say, why are you waiting so long? What takes you so long to look at, where's the dynamics? It's a really delicate balance, and you have to really explain it to your target audience to make sure they strike the balance right. And also, at some point, you have to move, you have to file the action, and you have to get it going. But for sure, it's a delicate balance. And for the defendant side, of course, the earlier the claims are filed, the easier, because then you get positive precedents in the first place, and you can refer to that for the cases coming down further down the road.
Chris, do you want to add anything to that?
Only just that cost budgeting can be a good tool, and it's adopted in certain ways by the English courts. But for me, it's very much a case-by-case assessment. So you might have two claims worth £20 million, and cost budgeting is suitable for one but not the other. And I would echo everything that Christian said. It's so important to work out whether it is going to assist in the particular situation in question. Very often there'll be budgets performed because third-party funders will require it, and so there'll be some budgeting that's done. But in terms of management before the court, I'm cautious before suggesting that cost budgeting is something that judges should easily get involved with.
Lochy, do you have any views on this?
Yeah, there's a few things that I would sort of pull up. The first is probably that you're going to have to choose at various stages what you're going to get and what you're going to get at what cost. There are certain quick wins that you can get in the bag early on to keep costs down. So pre-book build is a good example. There are lots of engaged netizens out there. Claimant groups will self-form on Mumsnet, and I've seen them on Facebook groups. There are all sorts of places where people are much more engaged now than they previously have been. They're willing to do a lot of the work up front that you might have previously had to do. They've already formed a class in some respects. So the choice is always going to be there, and I think you've got to follow the kind of 80-20 rule in terms of keeping costs down, which is you've got to choose what fat can go. You can probably keep things moving and take 80% of the gain with about 20% of the work, and it's an art, not a science, to look at claimants coming in, to look at evidence coming in and say, actually, this is interesting, but we are not going to engage with this. We are going to follow down a more standardized route here. Somewhere else, we're going to choose to spend additional time. So I think the kind of shortest answer I could give to that in terms of keeping costs down is choose what is worth pursuing and don't get too caught up in the details.
Well, that seems like very sensible advice for us to finish on, unless there are other questions? Well, I'd like to thank my panel for your insightful comments and discussions, and thank you to all of you.